Hello friends, welcome to my channel's MITUSIR'S classes. Now I am going to discuss about Indian polity article of the Constitution. Indian polity article of the Constitutions. Article 32. Article 32. Article 32 remedies for enforcements. Remedies for enforcement of fundamental rights. Remedies for enforcement of fundamental right, including writs. Remedies for enforcement of fundamental right, including writs, or right to constitutional remedies. Right to constitutional remedies. Next, Article 32. Article 32 is not a right. Article 32 is not a right in itself. Article 32 is not a right in itself, but it provides the mechanism. It provides the mechanisms to protect the fundamental. But it provides the mechanism to protect the fundamental rights contained in part 3rd of the Constitution. Contained in the part 3rd of the Constitutions as a matter of fundamental right. As a matter of fundamental right. Article 32 is not a right in itself. Article 32 is not a right in itself, but it provides the mechanisms to protect the fundamental rights. Mechanism to protect the fundamental rights. It contained in part 3rd of the Constitution. Contained in part 3rd of the Constitutions as a matter of fundamental rights. As a matter of fundamental right. Next, Dr. Bhimrao Ambedkar. Dr. Bhimrao Ambedkar has termed these articles as the heart and soul of the Constitution. Heart and soul of the Constitution. Dr. Bhimrao Ambedkar has termed these articles as the heart and soul of the Constitutions. Next, writs can also be filled. Writs can be also be filled in the High Court. Writs also filled in the High Courts under Article 226. Writs can also filled by the High Court under Article 226 of the Constitution. To Article 226 of the Constitution. These articles laid down the provisions for enforcement. These articles laid down for the provisions of the enforcements of the fundamental rights, or enforcement of the fundamental rights within the chapter of the fundamental rights itself. Within the chapter of the fundamental rights itself, these articles laid down the provisions. These articles laid down the provisions of the enforcement of the fundamental rights within the chapter of the fundamental rights itself. Within the chapter of the fundamental rights itself. Next, right to move the Supreme Court. Right to move the Supreme Court by appropriate proceedings. Right to move the Supreme Court by the appropriate proceedings. Proceedings for the enforcement of the fundamental rights. Conferred by this part is guaranteed by Article 32. This article is guaranteed by the Article 32. This part. Right to move the Supreme Court. Right to move the Supreme Court by appropriate proceeding. By the appropriate proceedings for the enforcement of the fundamental rights. Confirmed by this part. Confirmed by these parts. Guaranteed by the Article 32. Guaranteed by the Article 32. Next, Supreme Court shall have the power. Supreme Court shall have the power to issue directions or orders. Supreme Court has the power. Supreme Court shall have the power. Supreme Court shall have the power to issue writs, order and directions. Supreme Court has the power to issue directions, order and writs. Next, there are five types of writs. There are five types of writs that are issued by the Supreme Court. There are five types of writs that is issued by the Supreme Courts and High Courts. Supreme Courts and High Courts for protections of fundamental rights. For protections of fundamental right. There are five types of writs that are issued by the Supreme Court and High Courts for the protections of fundamental rights. Five writs are habeas corpus. First one is habeas corpus. Second is mandamus. Third one is prohibitions. Fourth is certiorari. Fifth one is quo warranto. First one is habeas corpus. Second is mandamus. Third one is prohibitions. Fourth one is certiorari. Fifth one is quo warranto. Next, first one is habeas corpus. What is habeas corpus? Habeas corpus literally means to have the body. Habeas corpus literally means to have the body. Means to have the body. Next, in this reads court orders. In this reads court orders of a persons who have detained. In this reads court order of a person who have detained another to produce the body of the detained person before it. Another court of the body to provide to the detention of the persons before it. Third one, court can set the dentifrice. Court can set to the dentifrice if detention is found to be illegal. It is found to be illegal. In these processes, court found this matter is the illegal. Fourth, this read provides safeguards against the arbitrary actions. These reads provide the safeguards against the arbitrary actions of states or executive and an individual Next, a court cannot issue this writ. A court cannot issue this writ if detentions on order of any court of law. If the detentions of the any detention on order of the any court of law. Next, when detention for contempt of the legislatures of the court. When the detention is the contempt of the legislations of the court. Next one is the mandamus. It literally means we command. This writ is issued against the executives and inferior judicial bodies. These writs is issued by the against executives and inferior judicial bodies to perform their duties. In which they have failed to perform. This writ issued against the executive and inferior judicial bodies to perform their duties in which they have failed to produce. This cannot be issued against a private individual or body. This cannot be issued against a private or individual bodies or body and president and governor of the state. This cannot be issued against a private individual. This cannot be issued against a private individuals or a body and president and the governor of the state. These writs also command activity. This writs also commands activity. Next, prohibitions. Prohibitions literally means the forbids. Prohibitions literals means to forbids. These writs issued against judicial and quasi judicial bodies. These writs issued against judicial and quasi judicial bodies only. Next, higher court issue these writs. Higher court issue these writs against subordinate courts. These higher court issue this writ against subordinate courts. Subordinate judicial bodies to stop them from going beyond their jurisdictions. Subordinate judicial bodies to stop them from going beyond their jurisdictions. Next, this writs command inactivity. This writs command inactivity. These writs command inactivity. This writs command inactivity. Next is certiorari. This writ is issued against any judicial. This writ is issued any judicial or quasi judicial body by a higher court. Quasi judicial body by a higher court. Next, it is issued quash the order. It is issued the quash the order of a inferior judicial. It is quash the order of a inferior judicial body or to transfer any case itself from a lower court. In case of a lower court, it is issued or quashed a order of a inferior judicial body, judicial body, or to transfer any case, to itself from a lower court. Next, this can be done on the basis of error of law. Or excess judication issued by the court. This can be done on the basis of error of the law or excess judications issued by the court. Next, certiorari can be issued. Certiorari can be issued even after a case has been judged by a subordinate judicial court. Case can be judged by the subordinate judicial court. Certiorari can be issued even after a case has been judged by a subordinate judicial court. Next, it is a curative as well as a preventive. Next, Q warranto. It literally means that what authority. It literally means that by what authority. Next, it is issued to ensure. It is issued to ensure the legality of the qualification. It is issued the legality of the qualifications of the person holding an office. It is ensured to the legality of the qualifications of a person holding any office, holding an office. Next, it is issued in the case of any substantive public office. It is issued in case of any substantive public. It is issued of any substantive public office and not against private office. Next, it asks that by what authority. It asks that the by what authority you are holding an office. It is asked by the what authority is holding by an office. Next, this article guarantees the remedy for violations of fundamental right. This article guarantees the violations of the remedy for violations of the fundamental right. Remedial right itself of a fundamental rights. Remedial rights of a fundamental rights. National Emergency Article 352. National Emergency Article 352 is proclaimed to the President. Is empowered to suspend. Proclaimed to the President is empowered to the suspend this right to move to the Supreme Court. This right to the move to the Supreme Courts on violations of the fundamental rights under Article 359. On the violations of the fundamental right under Article 359. Next, a law duly enacted by the legislature. A law duly enacted by the legislatures is considered valid. Events it is contrary to principles. It is contrary to principles of the justice and equity. It is contrary principle to the justice and equity. A law duly enacted by the legislature. A law duly enacted by the legislatures is considered valid, even if it contrary to principles of justice and equity. It is a contrary to the principles of the justice and equity. Thanks. Please share, subscribe, click the bell icon. Thank you.